Studying business law and want to know more about minority shareholder protection? In this podcast, Dr. Yanis explains how those who find themselves in a minority within a company can defend their interests. The podcast is especially relevant to those preparing FLK business law for the SQE or studying company law in England and Wales.
I want to talk to you a little bit about what happens to minority shareholders. In any type of corporation, big ones and small ones, there should be no expectation that we've got an equal balance between the people who own the shares. It's very common that there is a majority shareholder and somebody comes in on a smaller investment. It could be that somebody wants to invest a little bit at the beginning and not to be fully invested, or somebody comes in a little bit later on and invests some additional money, brings in something in addition. But there's a weakness in being a minority shareholder. As with anything, nobody normally has a great time being in a minority, do they? I mean, the whole point of constitutional law and constitutional provisions, and the whole point of law to begin with, is to make sure that everybody benefits from the same treatment and has got like comparable rights and obligations. And this is even more important if you belong in a minority group and you're frightened that the majority might decide to do things that go against your interests, and if they decide to do this, there isn't much you can do about it. So there are mechanisms, or there should be, if there aren't, there are mechanisms there to protect people who are in a minority position in a corporation. How would you feel if I told you, I am trying to branch out, I'm trying to raise more money, and I'm selling a 10% share in my company. So, my company is doing great. You're going to participate in the success of this company, and you can buy 10% of the shares. You don't have to do anything at all. As a shareholder, you don't have to do anything, right? I mean, you have the opportunity to participate in the general meeting and in certain types of decision making if you choose to do so. You're not obligated to do so. So I could offer you for 10% of my shares, you pay for those, you become a shareholder, you benefit in my success. When I pay out dividends, you get a nice chunk of this. It's a great deal. But there's one problem. It is a great deal, but if I decide to do stuff that are actually a terrible idea, you have very little influence over what I do. Voting at general meeting either takes place on a majority or a supermajority. Obviously, in order to change the Articles of Association, you need the supermajority because you're changing the kind of fundamental structure of the corporation. But look, if you're a 10% shareholder, I can take decisions on an ordinary majority on a daily basis if needed. I can change the Articles of Association because I also have a supermajority. I've got 75% of the shares and above. So I can actually do everything I want, and there is no way you can stop me. And if it's a private limited company, it's not even easy for you to get out. Because in a public corporation, especially for one listed in the stock market, if things don't go your way and you think the corporation is not performing up to your expectation, you just sell your shares and then the next person has to worry about it. But if you're in a private limited company, it's not easy to exit. It might be difficult to find somebody to sell the shares to. And it needs the consent of other people. It needs a change in the articles to be able to get out and all of that stuff. So it's going to be problematic. Therefore, we have an issue as to how to cater for the interests and make sure that people are committed, the people running the company are committed to benefiting everybody and not just the people in the majority. So it is still possible and within the law that a director is making decisions for the company that are beneficial to the company, broadly speaking, but could be detrimental to a particular shareholder. Can you think of an example of how a decision could be legal and beneficial to the company, but at the same time detrimental to individual shareholders? The company has good profitability, and instead of returning part of that benefit to the shareholders in the form of dividends, they choose to reinvest. This could be the right thing to do for the company. So the company can grow and become more successful in the future. But you're not going to be a happy bunny If first year you're in, you don't get any dividends. Second year you're in, you don't get any dividends. Third year you're in, you don't get any dividends. 20 years down the line, you don't get any dividends. So you've blocked your money into this investment and you're not really getting anything out of it other than the promise of selling them at a better price in some indeterminate place in the future. If they are raising additional capital, they wouldn't be able to discriminate against existing shareholders. That might be a concern. You might be thinking, I understand my participation in the company on the basis of the existing shareholding. If they create lots of additional shares and I don't have the capacity to participate and purchase those additional shares, then gradually my position is getting diluted. So, yeah, that could be another example of the company raising finance through additional shareholding, or perhaps the company taking in debt or doing something like this that might be good for the progression of the company, but might look like a dangerous or unpleasant thing for one of the current investors. So it's possible that the directors are taking decisions that are correct and appropriate, but individual people have a problem with them. When we're talking about minority shareholder protection, we're not talking about this. We're not talking about giving you like a free exit whenever you're unhappy, or giving you the rights to complain as an individual because this investment is not going in the way you wanted, or the direction of the company is not in the way you wanted. This is the way company law works. This is why you have a board of directors, and this is why they've got the ability to make decisions on behalf of the company and specific parameters within which they make those decisions. So this, you being unhappy for yourself, isn't a reason to complain. The whole discussion about minority shareholder protection is when in fact something's going wrong. The directors are disrespecting their boundaries, or they're taking decisions that are bad for the company, or they're taking decisions that benefit specific members of the company to the exclusion of everybody else, and they're doing this on purpose. That's the thing that we're focusing on. As we've seen previously, one avenue of reacting to this, if you are a shareholder, you're part of the general meeting, but you're not the director yourself. One avenue of reacting to management doing the wrong stuff is to bring a derivative action. But that is an action that defends the company's interests against misbehavior from the board. If you have a situation where there is a group of directors that take very, very bad business decisions, then you might be thinking as a shareholder, is there anything I can do to stop them? Or if they've done the thing already and the thing has caused damage to the company, is there any way that the company can recoup money from those directors because they've done something wrong? At which point you need to consider, is the wrong thing wrong in a business sense, or is it the wrong thing in a legal sense? For it to be wrong in a legal sense, it needs to be a breach of director's duties. And it needs to be a breach that causes harm to the company. The company itself is not willing to do anything about this. So then it falls to you as an individual shareholder to bring an action on behalf of the company and try and convince the court that the company has a cause of action against these people and it should be pursued and it will have a beneficial outcome if they're successful. Section 260 gives a statutory right to shareholders to appeal to the court to get permission to pursue an action on behalf of the company. And if the court thinks that it will be in the interest of the company to pursue this action, meaning there's some initial evidence that some violation has taken place and there's some initial evidence that some loss has been suffered, then the court will allow the action to proceed. Which is great, right? So we've got some things that can offer some protection to people who are not in a commanding position. I mean, you could argue that the fact that we've got different weighting for decisions at general meeting is some protection by itself. So if you need 50% for an ordinary resolution and 75% for an enhanced majority, then you ensure that with 75 you got enough volume of people who want to do something to make it a valuable thing to do. We were talking about ways in which somebody in a minority position that doesn't have a great degree of influence can do something. So one of the things that they could do is, if they're not a tiny minority, maybe they've got more than like a quarter of the votes at general meeting. If you've got more than a quarter of the votes, then you can block special resolutions. So at least you can, if you're a minority but not a tiny minority, you've got some level of control in excluding changes to the Articles of Association. So there's something. Now, what else can you do? The key difficulty is disagreeing with what the majority is doing. Disagreeing with what the board of directors is doing is already quite limited. Because as we said, they're entitled on the basis of the law, on the basis of the Articles of Association, they're entitled to run the show. So if as a shareholder you disagree with what they do, you have limited room to express that disagreement. But if you disagree with what the other shareholders are doing, like the majority of the general meeting, then you're even in worse trouble. Could you go and say, I'm in a minority position, but I want to be protected from other people messing with me, and to have this expressed in the articles somehow? Could you carve out specific protections within the Articles of Association for people who belong in a minority? If they're doing something nasty to you, and I'm going to get there in a moment, if they're trying to do something nasty to you, there are some mechanisms to protect you. But could you be kind of forward about this and say, I will join the company, I will only get 10% of the shares, but I want some protections built in the Articles of Association as I'm coming in that we agree now. People in a minority position, a different class of shares, then that is a contractual, if you want to call it that, because it's expressed in the Articles of Association, but it is a valid mechanism to give them an extra layer of protection. And having somebody belonging in a different class of shares, it doesn't necessarily mean they're getting a great deal, they're getting a worse deal. It just means they're getting a different deal than everybody else. So it is entirely possible that you've got somebody joining in a minority position and you don't give them ordinary shares, you give them a different class of shares. Then, if that's what happened, the rest of the company cannot change the rights that are attached to that class without the consent of the class. And if it's only one person that is the total majority of that class, it means that they're secure from changes to their entitlements, at least in the way that they're expressed in the Articles of Association. So if I want to contribute to this company because I want to participate in the financial success, I don't want to be involved in day-to-day management, I don't want to do anything, but because I'm giving in extra cash that the company wants, I want to be doubly rewarded. So we could say that I am putting this 10% of the 10% of shares that I'm buying for myself, they actually have double dividend entitlement. Or the dividend pays first at a higher amount than everybody else. And this is written in the Articles of Association. The company cannot change their minds about this. Because if they decide to pay dividends, then the distribution is preset. I'm going to get, if it said double for me, I'm going to get double. So whatever they gave as dividend per ordinary share, I'm getting twice that. They cannot prevent me from doing this without changing the rights of my class, and I'm not going to say yes because I'm not stupid. Or if I say yes, it's part of a negotiated settlement, they give me something else. They're going to say, look, your class doesn't work for us. We're going to change the rights of your class. Everybody has ordinary shares, but we're going to double the amount of shares that you got. Right? And that's your incentive for switching. Creating a separate class of shares is a terrific way to embed some protections for people who are in a minority position. There are some other stuff that you could do. For instance, there is the idea of entrenchment. This is in Section 22 of the Companies Act. You can make some provisions in the articles subject to change only by the complete agreement of the company. You can class any provision in the Articles of Association as something that requires a supermajority to change. So you could say this, like, there's a provision that says something, if you want to change that one, it's not like the rest of the articles I want an enhanced majority. You could even say, I want 100% agreement of all the shareholders in order to change this. Now, that would mean that certain articles that have been entrenched can only be changed if absolutely everybody agrees. So if you're in a minority position, no matter how small a minority you are, unless you agree, they're not going to be able to change it. Weakness with this idea is that entrenchments can only happen at the point of the creation of the company. So you need to be there at the beginning. Or, alternatively, you need to get 100% of the shareholders to agree to entrenchment. But this is a little bit unlikely if you're joining the company at the later stage. One of the mechanisms that we've seen in the past as well would be an external contractual agreement between the shareholders, because you can always have shareholders' agreements that they say they're going to do things in a certain way. You remember what is the problem with shareholder agreements? No, it's not binding to the company and it's not binding to future shareholders. So if we sign a contract, the two of us, it's between the two of us. If other people come around, then you cannot say, because of the contract we have between us, other people have got rights and obligations. So if there is a shareholders agreement, it means that if somebody subject to this agreement changes their minds and they do something, they're going to be in breach of contract. So then you can sue them in damages for breach of contract. But if you got new members coming in, clearly they're not covered. So it is a way to kind of embed some rights, but not the terrific level of protection. So we have putting stuff in the Articles of Association, entrenching things in the Articles of Association with higher majorities, external shareholders agreements, splitting people into separate classes of shares. All of these are mechanisms that can give a greater degree of confidence to somebody in a minority position that they're not going to be messed about, but none of it is a complete agreement. The key issue that normally tends up in the courts in this area is people disagreeing with decisions of the majority. And it is a sad and painful area of company law that consistently generates new cases that go to the courts. Now, if you're wondering, well, if we got so much case law on it already, why do these things end up in the courts all the time? They end up in the courts because people are fighting over the facts. They're not fighting over what the law is. That's why most things end up in the courts. It's not like we don't know what the law is and we want the judge to tell us. It's like we know what the law is, we just disagree what our rights and obligations are on the basis of the factual basis that we have. Now, the key problem that we've had is expropriation. What happens if the majority of the company decides to expropriate a minority? What happens if I've got this 10% shareholding and 90% of the shareholders say, we're going to change the articles to buy back those shares or buy you out? It's like, we don't want you out anymore, goodbye. So I'm getting kicked out. What am I going to do about this? Now, it might sound like this is an abusive thing to do. Why are you kicking out a minority? But the rule is, and you can see this in cases like Allen and Gold Reefs of Africa, it's a case from 1900. You got Brown and British Abrasive from 1919. You got Sidebottom and Kershaw from 1920. All these cases remind everybody that the company, as a unit, takes decisions for the benefit of the company, not for decisions of individual members. So if the company decides to expropriate a minority, if this is the right thing to do for the future of the company, it's going to be okay. I know that this sounds horrible, right? Doesn't it sound horrible? That they might take decisions to exclude you and kick you out, and there's nothing to do about this if the change is in the interest of the company. Can you think of a reason why it would be in the interest of the company? But you see, it can't be personally targeted, because if the majority thinks you're annoying, then that's not really deciding to kick you out because you're annoying. This seems to be like a kind of one-on-one personal thing, like a difficulty in the relationships, as opposed to an action that is in the interests of the company. So for something to be in the interests of the company, it has to be in some sort of reorganization context that's not personal. So you've been like a minor shareholder. We're having a new investor coming in that wants to buy 90% of the shares, or it's like in a merger scenario. So in that case, you might get kicked out because there's a major investor coming in that's got a different plan about how the shareholding is distributed. So it's not like we don't like you personally. It's like this is the right thing to do for the company going forward in the way they organize their finances and so on. So the court has said in all of these cases that what matters is that the interests of the company are behind the decisions that are taken. And this informs both decisions of the board of directors and also decisions of the general meeting. And it takes us back to discussions that we had in the past about how shares are primarily perceived as economic entitlements, financial entitlements, and not property rights. So we've got this tension all the time. Should we consider shares a property right, or should we consider them a financial entitlement? If you consider something a property right, you've got a closer link between the property and its owner. It's very difficult to expropriate property. But if you consider something a financial entitlement, what you're interested in is not the asset itself, but what it represents in terms of money. So if I were to take your laptop, you would have a problem with that, because this is your asset, this is your property, it's something that you're kind of more intimately connected with, like your laptop or your phone. But if I were to say the bank in which you have your bank account is closing, therefore you were transferring your bank account to a different bank, then you don't care if the money is the same, right? Or your electricity provider is shutting down, or they sold to somebody else and they're transferring over. You don't care. I mean, it happened to me. I was with, the electricity was provided by Co-op. Octopus was the one with the pink octopus, right? They bought the Co-op. So I received a letter that says, your account, your electricity supplier is now changing. Your account is getting transferred over to Octopus. And it said, of course, if you don't like it, because it's a change of contract, if you don't like it, you can leave altogether and go to somebody else. But the fact that they were changing over in the same terms and conditions, nothing was changing for me. I don't care. So long as the lights turn on when I click the switch, I don't really care who supplies the electricity, and the price is the same. Equally, if I have a bank account in NatWest or if I have a bank account in HSBC, so far as the rights attached to it are the same, I really don't care. But if they said, we're going to take away your phone and give you something of equivalent value, or your house, give you something of equivalent value, or your dog, you might feel differently about it. So they cannot, I mean, it's very weird that going from cases to cases, the courts cannot make up their minds as to whether shares should be property rights, that we should really keep them with their owners, or whether we should just consider them the equivalent of an amount of money. In all these discussions, how should we protect the rights of a minority, and are we allowed to kick them out if it's in the interest of the company? The position seems to be, this is money, who the hell cares? So the only thing that matters that comes out of all these cases is whether there's an independent and adequate valuation of the shares. So if it's independently valued, then you get the money, and it's like, that was the right thing to do, thank you for your service, goodbye. Actually, in the context of a merger, you got section 979 of the Companies Act that says if the acquiring party attains 90% of the shares, then they have the right to force everybody else to sell. This is something that's expressed in areas of property law as well, to be honest, because, this was 979 is the section. If somebody has purchased 90% of the shares, then they can, in a compulsory fashion, expropriate the rest of the 10. They don't expropriate, they compensate, but they buy the rest of the 10%. Because otherwise you would make the functioning of the company weird and uncomfortable if you had like a 10% complainer group stuck in there to kind of be as a wedge to every decision you're trying to make. If in the stock market, somebody is wishing to purchase the totality of the shares to take a company private, to take them out of the stock market, and they get they hit 90%, they can get the remaining 10%. And the people who've got that remaining 10% cannot object. So long as, of course, that they're compensated adequately. In the Twitter situation, Musk was actually paying above what was the market valuation of the company. So there was actually no reason to complain on the money. The only test that we've got that is checking this is whether the decisions are taken in good faith. So is the decision in the interests of the company? How can we tell? Because it's not the job of the court to kind of second guess decisions of the board of directors, but they kind of have to think where the decisions taken in good faith. So the only way you could challenge it is if you find that actually, you know what, they're not doing this because they think it's the best idea, but they're doing this because they hate me personally, because I challenge their policy, or, we have a personal thing going on, etc. Limited grounds, therefore, for somebody to resist decisions that are taken by the board or to resist decisions that are taken by the general meeting on the basis that they don't agree with the decisions. This isn't how company law has organized stuff. But what if they are actually out to get you? Derivative action is not going to help you here, because the derivative action wasn't they're out to get me. It was like they're doing bad things and damaging the company. So, either they're incompetent or they've got some sort of evil agenda that affects all the shareholders. What if they are actually out to get you? The mechanism for this is in Section 994 of the Companies Act, and this is called unfair prejudice. So you're going to the court and you can complain that the company's affairs are being conducted in a manner that is unfairly prejudicial to the interests of the company generally, or to some of the shareholders, or just to you. And this can relate to things that the company has already done or things that the company is planning to do. You can do this and go to complain to the court for your personal protection. What sort of things are you going to complain about? If it was simply about violations of rights, so if you simply wanted to say this is a breach of directors' duties, etc., then you won't really need this, because you can always bring a derivative action. Yeah? This is to protect expectations that you have that could either be expressed in the Articles of Association or in an external contractual document like a shareholders agreement, or, and this is significant, expectations that you had arising out of the relationship. So this is something that you can use to complain that your legitimate expectations are getting violated by what the company is trying to do. So that's why this is the unfair prejudice stuff is considered to be kind of wide-ranging and quite flexible, because you're saying they're after me because they don't like me or they're trying to mess up something, and our understanding is that we're going to do this differently. And they kind of change the tables on me, which kind of messes up the whole reason why I'm here. It negates the value of my investment, or is kind of targeting me as an individual. So you've got the entire opportunity to do this using what is found in Section 994. But you cannot simply use this to complain that they're losing you money. So you need your legitimate expectations cannot simply be, I got into this to make money, these guys haven't paid dividends in 20 years, therefore what I'm doing here. That cannot be. Right? You need to find something that is targeted and is a violation either of an expressed right or a legitimate expectation. And if they're trying to kick you out, so if you're complaining against an attempt to expropriate you, this isn't enough just in and of itself, because if they're paying you good price for yourself, for your shares, the court will consider that they're treating you fairly. And again, it brings back to what I was saying earlier, that this sounds kind of weird that they're ganging up on you and they're trying to exclude you, but the court will be very much focused on the idea that you're getting fair value for your shares. So what sort of situations do we have that we can actually nail down what is unfairly prejudicial? Because it's nice to say it can be a bunch of stuff, but it would be good to know what we can have. If you look at cases like Saul v. Harrison, which is a case from 1995, the court said that the conduct being complained about must be both prejudicial, in the sense of causing prejudice or harm, and also unfair. So conduct may be unfair without being prejudicial, or prejudicial without being unfair, but we need both of them to be the case. Right? Okay, cool, but that doesn't actually give us any concrete examples. In O'Neill and Phillips, that is a case from 1999, again, they were talking about things along the same lines. Now, the best example is, of course, the majority taking away financial benefits. So if they're doing things that put you in a worse position, or if you have a class of shares and they're doing things that undermine the value of that class, that could be something to complain about. But the best example of unfair prejudice complaints, and actually the majority of the cases in the courts, is about people having started a business with somebody else, and at some point they get into a fight and they get kicked out. This is where all this is coming from. And remember that the vast majority of corporations are small outfits where a bunch of people come together, and the same people are the shareholders, the same people are the directors, and they're coming together to run their business through a corporate form. So let's say that there's 3 of us, and we've been working already. We have a shop together. We'll be working as sole traders or as contractors in close collaboration. We're thinking, let's incorporate, right? And do this in a more predictable organizational form, take advantage of tax advantages, issues of dealing with liability, and all the rest that we can have through a corporate entity. And we incorporate. And we are the shareholders, shareholding split 3 ways, and we're also 3 of us are directors. And at some point, we get into a disagreement. I want to move the business online. You don't. You want to keep the business, and the other guy want to keep the business physical. And you guys, because there's 2 of you and 1 on me, and you want to keep it that way, you decide to kick me out because we don't see the same way about the company anymore and the future of the company. Now, the way in which the unfair prejudice provisions in Section 9994 can help with this is that I can go to the court and say, I had a legitimate interest in continued participation in the way that this company is run. So I wasn't in it simply to be a shareholder and a director from time to time. I wanted to be a director for all time. And I wanted to be participant in the decisions and discussions about the future of the company. So if we started off in being positions of shareholders and directors, and because we disagreed, you guys kicked me off the board, I'm a shareholder, my money is still invested here. But now, because I'm not on the board, I don't participate in anything, and because you guys have got 2/3 majority, you can do anything you want with the company at general meeting as well. So I have now 0 influence in what's going on, and I'm still stuck in the company. And this is unfairly prejudicial to me because this isn't what it was meant to be, and we create this company with another objective in mind. And the way this is expressed in the case law, these cases come under the label of quasi-partnership companies because they are companies, but in essence, they work like partnerships where all the people were supposed to be kind of in close collaboration with each other on what they do, right? So are we in agreement with this, that if there was 3 people that started to do something together and this was their livelihood, they didn't want to just be there as shareholders, they also wanted to be present in the board. So they wanted to be fully participant in running it, in deciding things, in distributing the benefits as shareholders when it came to it. So when they get into a fight and one of them is being excluded, the person being excluded, in fact, is losing something more than the technical rights to be a director if you get voted in. It's more fundamental what they're getting, and they're marginalized as a minority, and then they're left in a position that they're stuck. If that's what's going on, and you're successful in using this section to complain about it, what would you think is an appropriate solution? So what can we do for the person that's like the odd one out? I know, it sounds weird that the primary remedy for unfair prejudice is for you to leave the company, but it's the only rational solution. Because if people don't like each other, you cannot force them to work with each other anymore. It would be dysfunctional, and the company would not be successful. If they decided to part ways, what you can have is like a clean break, where they give you your money back and you go. Actually, not your money back. They give you whatever your investment represents right now, whatever the shares are valued at right now. And then you leave, and you can take your money and you can do something else with your life. So you're no longer stuck in this position of having no influence, but still having your money locked into this thing. On occasion, a remedy could be that the majority gets kicked out. Depending on what the facts are, it's also possible that the court is going to say, actually, you know what? The majority partners sell their stake to the minority if the minority is able to purchase it. And then the one person left carries out the company. If the company has become dysfunctional beyond repair, or the relationships are so damaged that the company would not be able to operate effectively, another possible remedy would be that they shut the company down. So the company is wound down and the money then is distributed to the people that were the participants. So there are all these options, that the minority person remains, that the minority person leaves, that the whole company is shut down. All of that is possible. The court will assess what is the most appropriate response in the circumstances. But the important thing to remember, and we'll finish with this, at least this part of the presentation, is think of shares as money, as financial entitlements more than property rights. And when it comes to things falling apart and people in a minority position feeling that they're in trouble, there are various ways that you can deal with this, both in the way that you organize the relationship on the way in that can help you, but on the way out, there is ultimately the ability to complain for unfair prejudice, and this again gives you a range of options. This is very contentious. People get into fights, relationships break down, people end up in the courts about it. It's something that generates lively jurisprudence. And even though we have clarity now, better than we used to, on what the law is and what are the technical steps to complain for unfair prejudice, it's still something that gets debated even on the point of the law. Sometimes you got cases like this that reach the higher courts that they talk about it. So it's an interesting area that can generate both kind of theoretical questions about how the law is evolving and practical questions as to how do you advise somebody who's in a minority position.